I believe the system is currently set up that we could turn that on and add all those fees in, okay? And I believe that it is correct in the system now. Mr. Wilson offered to make sure it was correct. I'm not going to talk about system.
And your client said no to that in an email, in writing.
Not recently. I don't know what.
Yeah, just last night, she was kind enough to email half the county and let us know that she wasn't interested in taking up the district attorney's office on its solution.
And I think, well, I haven't seen that email. Unfortunately, I didn't get a chance to look at my email this morning. I'm sure I must be copied on it. But I would say.
No, I'll tell you, it looks like your client sent it to everybody but you.
Well, I didn't see my email, so I have no idea.
Yeah.
Maybe she sent it to me. I don't know. So I think some of that might be because we think it is ready to turn on. So I gave you today a bill of costs for those cases
That are missing.
that complies with, that follows exactly what Grant County does, and we could fix this. What I want to do is help to resolve this clerical problem.
I hear you, and I'm going to take you at your word that this problem is fixed and it's ready to be turned on, and that I assume your client, you're telling us now, that is incorrect. When she sent the email saying she didn't want to cooperate with IT, she's willing to cooperate with IT. So what we're going to do is allow the system to be turned on, and we'll run new bills of cost, and we'll reset this to 11 o'clock this morning. But at that point, Mr. Sinclair, the court has had daily hearings. The court has had hearings over weeks. Your client has been begged and pleaded to get a bill of costs, and we still don't have one. So the court is likely going to find your client to be in constructive contempt of court if we do not have the correct bill of costs at 11, which you've told me can be turned on. We ought to have it in about 15 minutes. So we'll be in recess until 11.
If I may just clarify my statement, I said I think, first of all, and I was speaking as someone who was going through this yesterday, and then second of all, Your Honor, I would remind the court that the court has assured me that this is not a contempt proceeding.
It's not, but
And
the one at 11.
in the event the court decided that it wanted to turn it into a contempt proceeding, that it provide separate notice and separate opportunity to be heard.
Well,
I'm not prepared to.
Mr. Sinclair, you've had almost 2.5 weeks to be prepared. If we're not prepared, Mr. Sinclair, you know constructive contempt is very different from a formal contempt proceeding. Constructive contempt is the authority of the court to order somebody to comply with one of its orders, and if they don't, to impose consequences. At this point, the court has done everything to avoid reaching this decision.